Senator.
Morning.
How are you?
I saw Will, this note, they were writing that day, 8 o'clock last night. What? Sorry,
Because Senator,
Right?
it is not, the other thing is, it's not drafted. They'll draft it right.
Good morning, everyone. We are going to get started. It is February 27th, and this is the Pension Subcommittee of the Senate Budget and Taxation Committee. Welcome. We are going to hear Senate Bill 768, Correctional Officers Retirement System Membership Clarification.
Good morning.
Good morning, Senator. How are you?
Fancy seeing you here. Good morning, Madam Chair, members of the Pension Subcommittee. Senator Michael Jackson, District 27, on behalf of Senate Bill 768. Because we're in transition mode, I will, I think these are the last two bills, I will transition as necessary. Senate Bill 768 is a piece of legislation that makes a few clarifications to the membership of the Correctional Officers Retirement System, adding a few classes of employees of the Maryland Department of Health to the ranks of the system. I will turn it over to our expert, Ms. Gothrop, to continue, and I'll sit for questions.
Thank you, Senator.
We asked for a favorable report. I'm sorry. I forgot that part. Thank you.
Thank you, Senator. Thank you, Madam Chair, members of the committee. So this bill follows last year's bill that moved, it was enacted that as of July 1st of 2024 of last year, any security attendants employed by the Department of Health at a forensic facility in the state would be moved into the employee's pension system from the correctional officer system. What it didn't do is move all of the supervisors and managers in. Now, if those individuals are not moved from the employees to the correctional officer system as supervisors and managers, the ones that are currently in cores, if they are promoted to a supervisor or manager position, they would have to be moved back to the employee's pension system. So this bill would correct it, and we're hoping it would move any of the remaining supervisors and managers that are approved by our tax council to be able to be moved over, that this bill will address that. And our tax council is currently going through the list in the bill right now. So we will report back if there are any issues with any of the groups that are in there, and maybe, you know, if some have to be taken out, I will let you know.
Thank you very much. Are there any questions? All right. Thank you. That concludes Senate Bill 768. We'll move on to Senate Bill 810, Board of Trustees for the State Retirement and Pension System Investment Division Compensation and Staffing Committee.
Thank you, Madam Chair. Good morning again. For the record, Senator Michael Jackson, District 27, on behalf of Senate Bill 810. Senate Bill 810 repeals the Objective Criteria Committee of the Board of Trustees for the State Retirement and Pension System and establishes a Compensation and Staffing Committee of the Board of Trustees. The committee would include representatives from DBM and the Board of Trustees of the State Retirement and Pension System, with optional discretionary participation from both the State Treasurer and the Comptroller. And I will turn it over to you, Ms. Gothard. We asked for a favorable. I keep forgetting that.
I don't have much to add beyond, I mean, that's what the bill does. It creates a compensation and staffing committee for our board. It will be a committee of our board, and it will strictly focus on compensation and staffing for our investment division, not the rest of the agency, because those individuals, our board does not have independent salary setting authority over those individuals. We would like to, we have a couple of technical and clarifying amendments we'd like to add to this bill. The technical amendments, they're really in the weeds, and I'm not going to take your time with that. I'm going to work with your committee staff on that. But a couple of the clarifying amendments I wanted to talk to you about today. In 2018, when the legislation was first introduced, giving the agency the independent salary setting authority for investments, it provided certain forfeiture provisions within that bill that stated that the CIO and the investment division staff who earn financial incentives and leave employment with the investment division for any reason, they would forfeit that incentive comp. They would forfeit the financial incentives. So they wouldn't get it. Over the last couple of years, we've brought this to your attention, and you amended it to say if they leave directly, if they retire directly from employment with the investment division, then they could get any unpaid and earned incentive comp. We've missed one area where that forfeiture provision was in place, and that has to do with the provision that says the CIO and the investment division staff may not receive financial incentives in a year in which the state employees are subject to a furlough. The law goes on, current law goes on to provide that after the furlough period has ended, our board shall pay out any financial incentives not paid to the CIO or investment division staff during the furlough period only if the individual is still employed by the investment division. We're asking for that one other provision that said if they retired directly from employment with the investment division during a furlough period, they would get any unpaid incentive comp after the furlough period ended. And one more requested amendment to these forfeiture provisions. We'd also requested if the CIO or the investment division staff who are eligible for financial incentives, if they were to die while actively employed for the investment division, that their designated beneficiary would be able to continue receiving any unpaid incentive comp that they had earned at the time of their death.
Any questions? Concerns? All right. We're concluded. Senate Bill 810. Thank you very much.
Thank you.
Always a pleasure. We have Senate Bill 812.
Thank you.
Thank you. Law Enforcement Officers Pension System and State Police Retirement System Line of Duty Catastrophic Injury Disability. Senator Bailey and Senator Jackson.
Good morning, Madam Chair, members of the committee. Senator Jack Bailey, for the record, representing St. Mary's and Calvert County. This morning, I'd like to talk to you about Senate Bill 812, which would provide an enhanced line of duty disability allowance to be paid to a member of the Law Enforcement Officers Pension System or the State Police Retirement System who is found to be disabled and unable to engage in any substantial gainful activity after they've retired. Under current law, a member of one of these pension systems is disabled in the line of duty can receive an allowance equal to 2/3 of their pay. You often hear officers talk about they get 66 2/3. Last year, we did a joint chairman's report requesting that the State Retirement Agency report on how Maryland could award a special and accidental disability benefit for a catastrophic injury that resulted in a member of these two pension systems being unable to work in any capacity equal to 100% of the member's annual compensation at the time the injury occurred. This bill has been drafted to accomplish this objective and provide this increased benefit. This bill uses the federal definition of disabled as set forth in the Internal Revenue Code. The definition states in part that an individual shall be considered to be disabled if he or she is unable to engage in any substantial gainful activity by reasons of any medical determination, physical or mental impairment, which can be expected to result in death or to be of long continued and indefinite duration. The current 66 2/3 benefit is intended to account for the fact that about 1/3 of the individual's paycheck would be taxed otherwise. It makes perfect sense, right? However, this does not account for the other paycheck deductions that many of us are familiar with, particularly the cost of health insurance. The fact is, an officer who they have a spouse and they have a child. The spouse is taking care of the child. The officer is working. The officer is hurt in the line of duty. They get 66 2/3, and because of the other costs, such as health insurance, all of a sudden they are not able to meet their bills. Right? And they are not able, this bill would only affect people in a catastrophic situation where they're not able to make their bills. Right? And so now we have been working, and I want to give all the credit, right, to Miss Ann, because she has been very diligently at helping us, because I know how difficult and what, we really have to thread the needle to make sure that we do this the right way. And I just want to provide this enhanced benefit to our police officers who have been catastrophically injured in the line of duty, and to assure their income to continue to cover the cost of living, just like they were the day before that they were injured. So I also wanted to tell you that my good friend and colleague, Senator Jackson, is a big part of this, and obviously he was sitting in your chair last year and supported the JCR report, and so we are hoping to move forward, but I would ask for a favorable report. Thank you.
So I have one question, and you said that somebody who has experienced a catastrophic injury and cannot pay their bills. I'm simplifying it. But is that the case in this legislation? Or is it somebody who has been catastrophically injured, period, in the line of duty?
It is an officer that's been catastrophically injured and cannot have other gainful employment.
Okay, that's helpful.
Okay,
I'm just trying to get the clarification on the income.
That's the issue. It's not the person that just retired, disability, right, with an issue, and now all of a sudden they're running another business.
No,
Right,
that's not
this
what I was suggesting. I'm
Right.
just trying to understand the link between other sources of income and the injury.
Well, I think Ms. Gother could probably answer that, but this it didn't seem, a couple years ago when we first approached this, it didn't seem like it was going to be nearly this complicated. But when we deal with the IRS and the fact of the gainful employment is much more complicated, and that's why we ended up doing the JCR and studying some other states and working with that. But I would
And
turn
Ms.
it over.
Gothrop, my second question, I guess if you could address them at the same time, is in the course of the JCR, did you have a sense of how many people this would affect?
So to your first question about being able to pay their bills, we talked to 5 states, and our tax counsel and actuary gave us anecdotal evidence of other states. So it's all over the board as far as how the programs are set up in each state. There's no 2 programs that are set up the same way. What I found in the majority of the states were, if you come back and you are reemployed in any capacity, either for the public sector, in the private sector, that there would be a 100% reduction to your benefit. So it really is saying that the intent of this by the majority of the states is you're not having any other money come in. This is it. And then with regard to how many people this would affect, so again, in the 4 or 5 states I spoke to, once it ranged from one person since the program had been implemented 4 years ago, one person in that state had gotten the benefit. And then there was another state on the other end of the spectrum who had had the program in place since 2006, so almost 20 years, and only 76 people. But those states, it is really narrowly drafted, and it's very specific who can get it. There are reexamination provisions put in place. There are provisions that say income validation. So we would have to be able to look at 1090, or not 1099s, but, well, is it a 1099? I don't know what it's the one that you get, tells you how much you make every year. Oh, good Lord, I'm in front of a tax committee right now. I do pensions, not taxes, all right? So whatever it is that tells you how much you make a year, that we would need validation from that to show that you are not getting any income coming in. If this was the will of the committee that you wanted it to be that narrowly drafted, I think if you don't draft it narrowly, then you do have the possibility. I talked to one state that they let everyone come back, and so, but again, they didn't have that many. So that's been my experience talking to the people.
Madam Chair, if I might. There are occasions, if I might, there are occasions where members retire because of the injury, because they're no longer fit for duty. And that could be at different levels, a percentage of retirement, but they can't be law enforcement officers anymore. But then there are some who are catastrophically injured, who are paralyzed from a fall or a bullet wound to the spine or something like that. And so we're just trying to take care of those very few folks. And I am all for the record, I'm all for the reexamination, and the bill can be crafted as necessary, that periodically there is a checkup on these individuals because they are receiving these funds. And if they're out and, gainfully employed somewhere, then they're risking that benefit. So I am certainly for that. Having, my colleague here and I have both served in the capacity of union presidents or FOP presidents, and then I had the pleasure of being the sheriff of my agency. Your mindset kind of changes a little bit when your constituency changes, but we have a responsibility to take care of the folks who are providing this service, and most importantly, we have a responsibility to ensure that the funds are being expended properly. And
That's helpful. Senator Bailey, I just want to give you a chance to agree, disagree with what Senator Jackson just said, and whether it's your intention to go more narrow and really focus on the catastrophic nature of the injury or broader.
Thank you, Madam Chair. I greatly appreciate the opportunity to respond, and I would, I've always wanted to say this, ditto.
Great. Are there any questions? Great. Oh, Senator Sally.
Thank you. Thank you for the testimony and for the good bill. But just to ask maybe two quick questions about the experience maybe with the systems that they have in other states, and also whether the physical note regards the wording of the bill.
And I should have said this from the outset when I spoke the first time. The system, state retirement, is not taking any position on this bill. I'm just here to provide information. So I can't speak to the fiscal note, except, I mean, I did see where, your legislative, actuary is assuming that 50% of the current disability applicants would be converted into catastrophic. That's entirely possible, I guess, if you have if your bill is not narrowly tailored. That was not my experience when I was talking to the states that I did. And by the way, when I said I talked to 4 or 5 states, that's not because I was like, oh, forget about the other, 45 states. There aren't that many states that have this. There are only about 7 states that have this benefit. Right. And, my experience was, there was one state, this was the one, I believe, that only had the one person in the last 4 years. And in that state, the appointing authority, so my supervisor, would decide if I was catastrophically injured. I'm not sure that's the way the legislature would want to go. I don't want to speak for you, but we have a medical board in place that examines this, so that might be something you want to consider is with our medical board making these determinations. There was one state that had it set up as a long-term insurance program, and that was the state that I mentioned that said you can come back to work. Oh, no, I'm sorry. That was the state that said 100%, if you come back to work, we're going to offset 100% of what you were earning, and they're also going to offset Social Security. So some of these states I spoke to also offset any Social Security benefits that you were getting for the same disability. So the few number of states that are out there, like I said, none of them, no two are the same.
Right.
And also, what I think, you might want to consider is some of the states that have this program are trying to define what catastrophic is. Massachusetts, for instance, is really narrow and says it is only for public safety, and it is only for an intentional act of they refer to it as a violent act injury, and it is an intentional act taken upon the public safety officer, and it limits the type of acts. That's super narrow. So, I mean, I don't know if you would want to, because someone can be catastrophically injured. A trooper could be catastrophically injured hitting black ice, driving home in his patrol car. So.
From what I'm reading is actuary assumptions. And just looking at that, I mean, that's in question in itself. So that's why I asked that, but I appreciate that. Thank you, Madam Chair.
Are there any other questions? All right, we've concluded Senate Bill 812. Thank you very much. Those are all the bills we have to consider this morning, but we'd like to now take the opportunity to discuss some of the bills that we have heard in weeks past. And so I will turn to Philip to give us a little background on some of these bills and ask for your thoughts, and we'll proceed from there. Philip, thanks.
Thank you, Madam Chair. The first bill you have that you've previously heard is Senate Bill 200. This is a departmental from the supplemental retirement plans, and it is affecting a renaming of that program. Currently, it references Maryland teachers, but the program is really for state employees, and so the change would be to take out the reference to teachers. I think they mentioned they've been experiencing confusion among the population about who the program is for.
Any questions, concerns, discussion about Senate Bill 200? It's pretty straightforward. All right.
Is there a motion?
Is there a motion? Second? All in favor? Anyone opposed? All right. Senate Bill 200 passes unanimously.
All right.
Senate Bill 270.
Senate Bill 270. This is the bill. It's a bill that would require automatic enrollment in the supplemental plans for employees hired. I believe it's on or after January 1, 2026. There was, you've seen this bill before the past few years. There's been some amendments offered or referenced for consideration by the Treasurer's Office to try and address some of the concerns that have been raised. The first one, I think, actually, Jane, do we have a reprint? Do you want to pass that out? It's maybe easier to. So if you turn to page 2 of the reprint, the first one was just a clarification that for the higher ed institutions, the enrollment would be in a supplemental plan that those institutions choose. The next piece down towards the bottom half on page 2 for the default minimum contribution amount. This is a proposal by the Treasurer's Office to limit that default to not exceed $25 per pay. Now, the employees always have the option of changing that, either at commencement or in the course of their contributing, or they also, as provided in the bill, they can elect to cease contributing. And then the final amendment for your consideration on page 3 at the top was a requirement that employees be offered a virtual or in-person counseling appointment to discuss the plan and the timelines regarding discontinuing participation. I know there were some questions about the unwinding, so the 90-day period that's provided in the bill, that is not novel to this bill. That is an IRS standard. So the IRS allows, I believe it's between 30 and 90 days for an individual to withdraw their contributions from an automatic enrollment arrangement. What that means is that they would not be subject to the early penalty withdrawal. These are still tax-deferred contributions. So when they're going in, it's, you know, like any other, it's like your pension benefit, your other options that you do, IRAs, things like that. Those are not subject to income tax in that situation. So when you're unwinding them, they wouldn't be subject to the extra 10% penalty. They would still be subject to whatever income tax an individual would be subject to, provided that money had not gone into the retirement account and had just been in their check. So just to clarify on that, but the 90-day unwinding, it starts, I've been told the clock there starts from the first payroll deduction. So it's probably a little bit longer than 90 days from when employment commences. So I think that was one of the main concerns or questions that came up.
Other questions, Senator Salling?
I know some of the questions were, I think, and the concerns were the opt-out
Yes.
and also the unfavorables with ASME and the Maryland State Education Association. Were those concerns answered, or were there any other recommendations to?
I can't speak for those organizations as to whether the amendments address those concerns. I don't know if anyone's.
Senator Jackson?
Thank you, Madam Chair. And, you know, to the questions of working things out, we're still in the process of trying to work matters out with ASME. You know, we passed this bill out a couple of times. I will say that the plan has made a commitment to ensure that anyone wanting to opt out during the 90 days and, you know, the new employees will be contacted as a reminder that you have this option within the first 90 days. So they're not going to just come in through the agency to employment, and then, you know how it is. When you get hired, you start doing your job, and you're not really thinking about things, but they made a commitment that they would ensure that folks understand, you know, the opt-out ability within the 90 days. So I know that the treasurer is also in contact with ASME and some of the others as well. So I think it's an opportunity for us to, again, give our employees an opportunity to invest in themselves and retire. But you know, the legislative process can be a process that takes a little time. So there's always time to have a conversation. So, but I would move to at this point to pass this, and then we continue to work on it.
Are there other questions, Senator Salling?
Well, just to say, I just think I myself investing in funds for myself, for my future is an important thing like anybody else. I'm just thinking that those questions, if it's ongoing and they can have those conversations and they can be a part of that, I think it's good for them to have those times.
Absolutely.
Those opportunities. So.
The opt-out has been addressed, and we're working with ASME and others to address those concerns, but absolutely.
I would ask if we can hold this till a future meeting to continue some of those discussions. Is that okay? All right. We have a couple more bills. Senate Bill 457.
Senate Bill 457, this is a piece of legislation from the Joint Committee on Pensions. The Title 37 in the state pension code is one of the, I guess probably the only section in pension law that applies not just to the state plans, but also to other local plans for other jurisdictions. And it governs the movement between employees, between plans, and their ability to transfer service from the plan that they're leaving into the plan that they're going to. Over the years, there's been a number of instances where provisions in that title have been difficult to administer or unclear in terms of how they're actually to be applied. And so the system had recommended at the Joint Committee to conduct a work group that they would be staffing over the interim to bring everyone together, look at Title 37, see what is working, what's not working, what could be changed. So basically kind of like a mini code revision related to that provision. The bill lists a number of entities that would be included in that work group. I did, for your consideration, note, so the bill includes representatives from Baltimore City, Baltimore County, and Howard for their retirement plans. I would note that Frederick and Anne Arundel both also have defined benefit plans, and they were not noted in here. So if you wanted to be more comprehensive, the bill wouldn't preclude them from being considered, but if you wanted to just make it clear that, you know, they should be on the work group, we can add in references to those two counties.
Anybody have any issues with that, adding Frederick and Anne Arundel? All right, if we could do that, that would be
Okay.
great. Any questions about Senate Bill 457? Any discussion? Okay. Senate Bill 612.
612, this is another piece of legislation from the Joint Committee. When pension reform was done in 2011, there was language included addressing issues where there may have been people who had left prior to the reform taking place and were intending to return or just would end up returning. Over the years, that authorization for those returning members to resume had evolved. And so basically right now the standard is if somebody had vested in the old pre-reform plan, they can return and resume employment in that pre-reform benefit tier, including all the requirements and benefits. Those provisions were only included for the employees and teachers plans because those were the primary ones affected, and those are the systems that have the different benefit tiers. Over the interim, the system recommended or brought to the Joint Committee's attention that there were not similar provisions for Corps, state police, and LEOPS. And so this bill would add similar provisions where somebody who had begun before the 2011 reforms and vested and then returned to service would, if they came back, not be subject to the newer requirements. And primarily for those plans, it's the 10-year vesting and the calculation of average final compensation, because their benefit tier for the multipliers was not altered during the reforms. There is one amendment. As introduced, there was the inclusion for, so in the employees and teacher systems, there are 4 benefit tiers. The original was a non-contributory plan. Then there's what's called the contributory plan. Then there's the alternate contributory pension selection, and then the reformed contributory pension benefit. As introduced, those 2 older pre-reform plans, the non-contributory and the contributory, were added in, but upon review, the agency noted that the scope of that may be a lot broader than anticipated, and so the amendment for this one would be to strike those 2 employee and teachers tiers, and so that they can be reviewed more thoroughly over the interim so that there's no unintended consequences for the cost. And those would largely be covering municipal participating governmental employee units, because all the state units would either have it enhanced to the ACPS or the reform plan.
Are there any questions? Do you already have that amendment?
I don't have that, but it would be striking on page 1, line 20 through page 3, line 2.
Okay, why don't we, we'll wait until we have the amendment. Senator Bailey?
I have one question, just for Philip, if we're going to hold that bill, just so we could address it. But we're talking about going back to 2011 and talking about people coming back if they had left the state service. So when we talk about certifications and we talk about police officers, if they've been out of the system for over 7 years, they would have to maintain their own certification to be able to come back without going through a police academy.
Yeah, the provisions are not addressing or altering in any way whatever the qualifications for the jobs are. It's if you were previously vested under pre-reform standards, and you come back into a position that would be included in those plans, the prior retirement requirement, so the vesting and the AFC primarily, would apply. It's not saying somebody has to be brought in. It's not saying somebody has to be hired. But if they're hired, because being employed, membership in the system is a requirement. It's a condition of employment. So it's addressing that situation. It's not addressing any decision making or any personnel requirements.
That's what I wanted to verify. Thank you.
Any other questions? All right, we'll move on to Senate Bill 692.
Uh, 692, this is kind of the annual Joint Committee on Pensions bill that makes technical alterations and clarifications. As introduced, the bill would update some due dates for annual reports to better align them with the availability of the information to provide those reports. And then also last year, when legislation was passed to extend the period a member could be in the DROP program for the state police retirement system, an issue was uncovered related to the calculation of how long somebody can enroll in the drop period. So a few years ago, the legislature passed legislations stating that for a member of the state police retirement system, once they've maxed out their benefit, so once they've accrued the amount of service that would provide the maximum benefit under the cap, they would no longer make contributions, employee contributions to the system. The result of that is that basically everyone in the state police system, once they hit 28 years is the max out for them. So once they hit 28 years, they stop contributing. And since they stop contributing, the system is not adding any additional service credit. And the way the DROP program is worded, the calculation is you can participate for a maximum of 7 years, or the difference between 32 years and your service credit. And so the issue is for state police, once they hit that 28 years, they will only always have 28 years of service credit. And so the intent was to provide kind of a ceiling, and the impact is that for state police, you could have somebody like well beyond 32 years, but their service credit only says 28. So the fix that the Joint Committee came up with, because that was not the intent of the legislation last year, was to change the reference to service credit to a member's employment. So the calculation would be based on the years of employment and not the service credit, which has that feature of stopping its growth at 28 years. I do also want to bring to your attention, so typically every now and then something comes up during session that may need to be addressed, and I've been talking with the system, and they've noted that they may have something that this bill could be a vehicle to address. They're still looking into that, so if it's okay, if you want to hold that, I can follow up with them in the next week or so and see if there's a potential amendment that this bill could be a vehicle for.
Any questions about that? Senator Jackson?
Thank you, Madam Chair. Philip, you mentioned that someone is asking that they probably need a vehicle. Who is that? Who would that be?
The system is checking on whether there's another legislative fix that
Okay, gotcha.
may need to be done. I don't have the full details at the moment, but
Gotcha.
it may or may not be needed, so we're going to just, this bill could be a vehicle to make that
I appreciate it.
correction.
All right, thank you for the answer. And Madam Chair, if I might, Senate Bill 457, what did we do with that? We spoke about the amendment. Were we voting on that or holding?
No, we're holding that also for amendment.
Okay, all right, thank you.
All right. Let's move on to Senate Bill 693.
693, this is also Joint Committee on Pensions legislation. When members retire and are reemployed, they are subject to offsets depending on how much pay they're receiving during reemployment and how long they've been retired. Over the years, the amount has been increased. It's currently $25,000. The system brought to the Joint Committee's attention over the interim, there was no reference to a member's average final compensation being under a certain amount, excluding somebody from an offset for certain disability retirements. So the bill first adds in that exemption for disability retirees. The bill also, the Joint Committee, there was a recommendation that there was information provided that the $25,000 threshold was becoming outdated. The Joint Committee received a recommendation to up that to align with the minimum state salary. But the Joint Committee also altered that, and instead of just resetting it to the current minimum state salary, it will be tied to the minimum state salary. So as that state salary increases over time, the threshold for the reemployment offset will also correspondingly grow, so that you don't have to come back, every few years, or that it's not obsolete within a year or two because of inflation or growth in the state salaries. So that is that bill. I don't have any amendments on that one.
Any questions about that bill? Senate Bill 693? I think we're ready to move that. Is there a motion? Motion. Is there a second? Second. All in favor? Anyone opposed? All right. Senate Bill 693 passes. Thank you. Senate Bill 862.
862 is another piece of Joint Committee on Pensions legislation. The system for a number of years has been, its operational expenses have been funded through what's called an administrative fee, which is a fee charged to all participating employers. It's a per member fee that works to fund the system. Over the years, it's just become close to unworkable. It's become very complicated in terms of rectifying the accounting and the amounts. There's credits and surcharges based on the agency's budget and the way it's been done. There was a fix. There was legislation trying to fix some of the issues a couple years ago, and then over the interim, the system and DBM and DLS had gotten together to take a look at it, and the recommendation was to get rid of the administrative fees structure and fund the system through the employer contribution rates. This bill so the bill would, starting for fiscal 2027, the system, as part of its contribution rates, there would be a component of the normal costs that would be included to fund the agency's operational expenses. Now, I note this, so just to be clear, One of the things the legislature's also done is required local school systems to pay their normal costs for their teachers' retirements and pension system employees. That is reported to you all out by the actuary every year, and you get this information in the Joint Committee on Pensions so that you know what that normal cost rate is. I just want everyone to be aware, because the rates, we're getting rid of administrative fees and we're moving to funding the system through rates, that will be part of the normal cost. So next, when this begins, that normal cost may look like it's jumping up a little bit, and it will be, but the other associated costs with administrative fees are going away, so it's not a straight increase to the normal cost. It's more a shift of where the local participating in units are making those payments. So I just want everyone to be aware that it may look like there's a jump in that rate, but that would be why it's not an overall increase in costs. It's just moving where those costs are being assigned to those employers. I would note one thing, the bill as drafted, there's a question of whether, so the way the administrative fees are currently paid, they're paid quarterly. And so June 1st of each year is the last payment. The bill takes effect June 1st and is repealing the administrative fees statutory requirement. So I think the bill may need clarification on whether that, the intent is for that, the June 1, 2025 payment to still be made as certified previously by the board. So that would be an amendment for you all to consider.
Just to clarify what you were saying about the locals, so there's no net increase for locals?
No, not as a result of this bill, there will be no net increase on what the local employers would be obligated to pay. The only change would just be the natural growth in the system's budget, but they'd be paying that anyway through the administrative fees.
Okay, are there any questions? All right, so do people feel comfortable passing this and allowing you to do the amendment on the date?
Yeah, if you want
And
to.
then it'll be before full committee.
If you want to advance it to the full committee.
So could we
I can-
advance this to full committee? Or people feel comfortable with that? Okay, is there a second? All in favor? Anyone opposed? All right, thank you very much. We do not have other bills on this list. Is there anything else anyone would like to discuss? Otherwise, we are finished our business here, and I thank you very much. We will see you soon.